Good morning to all of you. The Honorable High Court of Madhya Pradesh, they have refused to quash the FIR registered against a TV celebrity, Ekta Kapoor. She is the owner of ALT Balaji Creations, which has produced very beautiful TV serials like Kyonki, Saas Bhi Kabhi Bahu Thi, and so many things. Right? So, a case was registered against Ekta Kapoor for publishing an obscene TV show by name Triplex Series 2. Triplex Series 2. By saying the name itself, hearing the name Triplex itself, definitely it is containing obscene pornographic material. So therefore, a case under section 67 of the Information Technology Act with some other sections were registered against her, basing on the complaint given by Valmiki Sakaragaye. I can't pronounce his name. Valmiki, let us assume he is Valmiki Sakaragaye of Indore, especially for dishonoring the people in army uniform, because the particular scenes in that web series disclose intimate scenes by army people in uniform. That is a major problem, right? So now she has approached the Madhya Pradesh High Court to quash the FIR registered against her. So under section 482 of the CRPC, and of course it was not allowed by the High Court. Here the important points raised by the defense, they are more important for you to learn as advocates, right? So it is clear that the High Court has refused to quash the FIR, right? Previously also a public interest litigation was filed of course before Allahabad High Court, seeking total ban on Triplex Season 2 because it is disrupting the Indian Army and their uniform. Of course, the plea was dismissed because the Allahabad High Court stated that whenever you wanted to ban the same, you have to approach the competent authority first. If they do not act, then you can approach the court like that. They have said that petition was dismissed because, of course, since they are relating to the same, this information I am giving you, right? So now we can read it as the case of Ekta Kapoor versus State of Madhya Pradesh and two others, 2020. It was decided on 11/11/2020 in criminal miscellaneous petition number 28386, 28,386 by 2020. Right? Honorable Justice Shailendra Shukla, he held that obscene films cannot be encouraged. We don't want to encourage the obscene scenes or obscene films or obscene TV shows. Very clearly stated, and he refused to quash the same because it is containing the obscene and dishonor to the national emblem. Right? So the MP High Court also stated that it is premature stage to decide whether the material is obscene or not. Whether it is obscene material or not is very premature. We can't unless some evidence is taken, because obscenity is somewhere, in some ways it is accepted, in some ways not accepted. Therefore, it is premature. They have cleared. Now, the FIR was registered on, of course, different sections of law, as I told you. Number 1, 294 IPC, 298 IPC. Of course, 34 is common intention. 67 of the Information Technology Act, 67A of the Information Technology Act, and Section 3 of the Emblems Act, and also Prevention of Insult to National Honor Act, Prevention of National Honor Act 1917. All these sections are there, right? I will give you brief lines. So Section 294 is related to public place. If anybody acts in an obscene way or if sings in obscene songs, definitely they are liable for punishment under Section 294 IPC, which call it as a petty case. Section 298, uttering words to wound the religious feelings of particular persons. Section 34 is common intention. Now come to Section 67 of the Information Technology Act. it says about the punishment for publishing or transmitting obscene material in the electronic form. Obscene means which is lascivious or prurient to the interest of the society, or which tends to deprave and corrupt the particularly young persons, corrupt young persons who are likely to see them. Of course, this is a serious case where the punishment will be for 3 years and fine may extend up to 5 lakh rupees. And they have added 67A also. 67A is regarding continuously punishment for publishing material containing sexually explicit act. This is more dangerous. That is obscene, here totally sexually explicit acts. Explicit means, implicit means a little honorable, and explicit means open. Then section 3, of course, this is Emblems Act. It says if the emblem is used to represent the government of India, if it is misused, then definitely it is also an offence under section 3 of the Act. Of course, National Prevention of National Honors Act, you may be knowing. If the flag is turned to the reverse side whenever you are on August 15 days, then you can be booked under that National Honors Act. All these sections were there. This is not important for us, but the points are raised by the Defense Counsel. So there are, I think, 6 or 7 points. Let us quickly, because time is not there, quickly resume them. Number 1, the defense says, Your Honor, already the internet it is full of obscene material. The government could not do anything. So what is the harm? Already, even and you may be knowing, Indians are among the 90% people who see the pornographic sites daily. And for this, the court said, no. It is because the concerned authorities are not able to devise a proper mechanism to prevent the same. Right? So such failure cannot be taken advantage by your petitioner. It is saying like that if one person tries to spread the garbage in a residential locality which is already unhygienic, if he says that already the colony is bad, it is unhygienic, unclean, what is the harm if I put my garbage there also? No, never do it. You have to take your case. No, you can't say that the internet is fully containing the so-called obscene material. Right? The second point, if a case is made it out against Ekta Kapoor, then you should make the company, Balaji ALT company, as the co-accused. For this, the court said it is for the investigating officer to decide. Of course, as far as we see the FIR, the complainant, Mr. Valmiki, he made the company also as co-accused. Of course, the police people did not make him. We'll see the reasons later. Then, third point, the intimate scenes are not graphic but simulated. They are simulated. That means just like if you see Kushi film where Pawan Kalyan's comments on the navel of that Bhumika, actually both of them were not at one place. Pawan Kalyan was at some other place. It is only just a simulation, that's all. Like that we have made. But still, they are not graphic, they are simulated. But the court held that whether we cannot say outrightly whether the material is simulated or not. We have to say whether the material is obscene or not. That is also, we can decide later, but if some more material is placed. We cannot outright say that they are simulated, they are not graphic like that. Then fourth point. So the TV show has clearly stated that this material is only to be seen by the adults. The court said, Arey Baba, whether adults or not, if it is obscene, definitely your people can be booked. Then, fifth point, the defense says it is against the freedom of speech and expression under Article 19(1)(a) of the Constitution of India. For this, court stated, my dear friend, you know that there are reasonable restrictions. These restrictions depend on the public decency and morality. We have come from ages where in the films, when you see that two flowers cuddling each other, it is an indication that male and woman, they are fond of love. We used to see that stage, that was also taken as obscene during those days. Now we have come to, of course, advanced, but please remember, this is not freedom of speech. If you express, if you definitely reasonable restrictions are violated, you can be booked. Then the defense lawyer says already we have clearly issued a disclaimer. Disclaimer was published that this program contains a strong language, mature and intimate scenes are there. Right? Okay. So whatever it is, even though you give a disclaimer, you say that these are not direct incidents, but if the incidents, if the section 67 is attracted, we can't help, because this case cannot be insulated with that thing, because if there are intimate scenes, if there are obscene acts, if there are sexually explicit content, even though you would give a disclaimer, it is not valid. Right? Lastly, so this is not a free for all. The defense says it is not a free for all, it is a subscription based site. That means whoever pays money, whoever subscribes for the channel, they only can see it. So since 294 says about a public place, it can't be allowed, it can't be taken as a public place. So for this court said, so please remember, public place, it is not defined in the IPC. So if you go to section 80 of the Information Technology Act, where in the explanation this was defined. So section 80 says about the power of police officer and other officers to enter and search any place. In this explanation, for the purpose of this subsection, the expression public place includes any public conveyance, means like that is a navy, ship, other things, any hotel, any shop or any other place intended for use by or accessible to the public. So public place where the public have got access, definitely it is a public place. So it is premature to decide whether it is obscene or not. Therefore, we are not going to quash the FIR. Very clearly, sir. But please remember, so whether it is obscene or not, only the investigation has to decide, and some more material has to be collected. Right? This is so normally this is one point I want to lastly. We have faced such case. Normally in Kerala at that time, the women folk used to actually not wear any angavastram on their breast portion. They used to move freely. Right? We have booked a case of actually this is 294 IPC against a woman for showing her breast portion under section 294 IPC. Then the defense lawyer asked me, suppose if it is in Kerala, is it obscene or not? I said no, it depends on different places. So likewise, definitely you will be put to that embarrassing position. That's why they stated that whether it is obscene or not, it has to be decided by the investigating officer. Is some material posted before us, definitely we will decide. So it is highly premature, but we cannot at this stage, your FIR cannot be quashed. So you have to face the wrath of the trial. That is what is informed to Ekta Kapoor. She has produced so many serials. I don't know why she is resorting to this type of triplex web series like that. She has a famous TV series has come. But anyway, it is her wish. We can't, it's a business, we can't help. But anyway, the points raised by the defense and the answers given by the court, they will be definitely useful for you while submitting your arguments using the bail petitions or quash petitions. That's why I have made this video. Please see it thoroughly and enrich your legal knowledge. Thank you very much.